Sonntag. Teres no historical analogue for the Supreme Court's idealized regulation of government employees by popular vote or political speech. Right?
Correct. Federal courts have abdicated the regulation of prosecutors and police to an unspecified black hole of political regulation, which has no basis in written law or tradition but only utopian communism. There's no tradition or written law in the United States that allows police and prosecutors to be directly regulated by popular vote, but the exact opposite. The design of our system is for government employees to be regulated by law through the middlemen of courts. Regulation of government employees by popular vote is a communist mirage which doesn't exist.
The term executive branch is a classification not a unitary actor. The term the people is a communist mirage without any legal definition. These terms are used by communists to incorrectly project the concept of a unitary mind and body onto fragmented decision makers.
The regulation of government employee discretion by politics does not exist in either history or reality, except in the primitive tribe or commune which had long been displaced by distributed decision-making at the time of the founding. The founding contained no immediate tradition of tribal collective control and no written reversion to it. United States law and tradition are the exact opposite of administrator discretion monitored by social perceptions of the collective. The new method of regulation is by laws and courts. This black hole of political regulation is a trick for courts to abdicate regulation by law with due process and claim tradition lets the powerful do whatever they want, because it is regulated in some unspecified way by voters and political speech. This is false communist nonsense. The new regulator in our system of government replacing the discretion of the king is not popular vote but courts and legislation.
In US verahimi, Justice Roberts describes method by which originalists arrive et Justice Barretts generally applicable principles in Vidal v. Elster.
A court must ascertain whether the new law is relevantly similar to laws that our tradition is understood to permit. Why and how the regulation burdens the right are central to this inquiry. The traditional term, the people, refers to a specific decision-making process, the Roman Committee of Centuries. The closest analog in the United States is the legislature. More general uses of the people now include electing executive branch administrators. But there's no pre-existing definition of this regulation by politics, no analog as originalists call it, which can be used to interpret law in the United States. To support the idea that what police do is up to the local voters. Tradition and law since the Magna Carta support that the regulation of government employees in the United States is intended to be done by legislation and courts as middlemen, not directly by popular vote.
Teres not actually any law or tradition no generally applicable principle by which the popular perceptions of a majority of voters can supervise government employees such as police and prosecutors. Only an eternal utopian mirage.
Numerous cases refer to some unspecified black hole of political regulation without pointing to a specific real or historical process. Judges instead casually imagine, as communists do, that the collective knows everything and can tell government what to do, that there is no information and supervision or corruption problem or structure needed to solve it. In Marbury, the politically examinable discretion of government employees was said to be regulated by an intimate political relation with an elected administrator who has certain important political powers, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and to his own conscience. Factory managers in the USSR were also accountable to country and conscience, but that did not mean they did anything useful. The activities of such communist administrators were not examined by hard realities, such as by prices or due process. Their conscience did not supervise their activities in the most profitable way.
Marbury specifically exempted individual rights, which were not given to the flawed conscience of prosecutors and police, much less to tire discretion regulated by popular vote.
When the rights of individuals are dependent on the performance of those acts, he is so far the officer of the law, is amenable to the laws for his conduct and cannot at his discretion sport away the vested rights of others. But where a specific duty is assigned by law, and individual rights depend upon the performance of that duty, it seems equally clear that the individual who considers himself injured has a right to resort to the laws of his country for a remedy. The province of the court is solely to decide on the rights of individuals.
In other words, administrators were deprived of discretion which was preferably given to courts in the case of individual rights. And to the maximum extent law could anticipate circumstances, and dictate actions for standard categories of events classified in advance.
Courts since then have abdicated the treatment of individual rights to the discretion of government employees and the utopian mirage of politics, without any legal justification to do so. Hudson v. Michigan refers to the extant factors of local politics. Herring v. United States calls social processes systemic. Imbler v. Pochman imagines the broader public interest is discovered by some method other than laws in court. Kansas v. Marsh refers to the community's general attitude. City of Grants Pass refers to the collective wisdom the American people possess.
None of this is supported by any written law or tradition, which support only the regulation of government employees through petitions in court to enforce the law, initiated by directly affected parties with first-hand knowledge.